Assalamu alaikum. Good evening and welcome to another episode of iON Legal Show where we discuss the law that works for you. I am Solicitor Farzana Karim and today I'm joined by a special guest, Mr. Ehsan Haq, who is specializing in property law and he's a very experienced conveyancing solicitor. Tonight we will be talking about residential conveyancing. We know that this is very important. Some of our when we think of buying a new house or to sell some property, we need to speak to a solicitor. Today we'll be talking about that. If you are a seller or a buyer or just curious about how it all works, stay tuned. We'll be breaking down each steps of residential conveyancing. Before we start, we would ask Mr. Ehsan Haq to introduce himself to the audience. And Ehsan bhai, thank you so much. Welcome.
No
Pleased to have you.
Thank you. It's a pleasure, Farzana. You invited me. Myself, I'm a solicitor for the last 20 years, doing conveyancing, mostly residential and commercial. I do general litigation, help people, and if the landlord in trouble, evicting tenant, this sort of kind of my expertise I do regular basis. Today, as Farzana said, we'll talk about residential conveyancing. I'll try to help you step-by-step explanation between pitfalls, pros and cons, if it helps. But what we advise, that's just the guidelines only. You must remember that it's not an advice from a solicitor. We just have to help you. Thank you, Farzana.
Thank you. Dear viewers, we have a number on the screen. If you have any questions about buying or selling property, feel free to call us on that number. Mr. Ehsan is here to answer all your questions live. And as we will be talking about residential conveyancing, let's start with what is residential conveyancing first, Mr. Ehsan.
Farzana, residential conveyancing, like every people dream in this country to buy a property.
Not only in this country, everywhere.
Everywhere. But since we're living in here, we thinking like or talking about the people in this country. How do they purchase property? Residential property mostly freehold, leasehold, which you can see used to see a lot of council flat, ex-council flat. Now there are a lot of private developer, and there's most of the flats are leasehold. The leasehold can be either 125 years, can be 250 years, or can be 999 years, 1 year less than 1,000 years.
Okay.
And then
that's the maximum.
Yeah, because if we go to the certain, if you exceed the 999 years, and if you are leaseholder, then you will have an entitled right to claim yourself as a freeholder, which no developer would allow you to do that, to become the freeholder, because of lot of legal technologies and in future problems could arise. And the properties are like share scheme property, a lot of developer to helping young people, or people are not capable of taking a large mortgage. So it's called share ownership, like you own 50%, the developer freeholder owns 50%, and you stay there and you do the 50% rent on that. So, and again we find a different type of property buyer. First, like first-time buyer, young people probably get an inheritance or gift from parents to buy a startup home. People like what we call the middle-class buyer, which is the more common buyer in this country. They actually buy mostly the freehold properties. Now, freehold properties is a property, it could be a flat, but very highly unlikely flat could become freehold. Sometimes you can see 3-bedroom house, it converted like 2-floor, 2 different number. So that can be like freehold virtually, but then both flat owner actually share the freeholds. That's only for converted house. Most common house is a 3-bedroom house with a small garden, and probably that's for the most of the people dream as a beginner home, which they can afford a lump sum, a quite reasonable amount of mortgage. or if they have a source of cash, they can buy it cash. So this is the most common three types of property. There are other some property like estate property, like my parents left or died, and we left a will, or if they don't, then we probably go to the court, get a grant a probate, and then with the probate, if I'm a beneficiary, I probably own this house as a beneficiary. This is actually the standard structure in this country, how to enter in the housing market.
Okay.
Banks are there to give you mortgage. Again, that's totally your affordability base.
Okay.
That's
Thank you so much. Mr. Ehsan was describing that various types of residential conveyancing. Basically, this is a legal process of buying or selling a home. So we told you that we'll be talking about each step. So from instructing a solicitor till registration, what are the steps we will hear from Ehsan?
right. To enter in the property market, first you need to actually figure out what's your limit, what's your budget, because no lender will give you 100% mortgage. It used to be like 10, 15 years back.
Okay.
There is a called self-certified mortgage. You declare yourself, I earn that much. You work in the bank used to give. Lending was much easier back in the early 90s, early 2000. Now it's obviously the buyers are a lot of numbers in the market. In proportion, houses are not in the market. So banks get stricter. You all know the interest has gone up since COVID, post-COVID. So used to people have, I remember I have done a lot of my clients' mortgage starting 1.25, 1.50 interest rate. Now that's gone like starting base interest at 4.5%, 6% some lender offers. So that's where we back to a fundamental question. Do you have the budget for that?
Okay.
Do you have the capability for that? If you overpass this and you are happy that you have enough fund to buy a mortgage, the next process you have to go to the state agent. You can buy privately, but very few transactions in this country, not much high transaction like between private buyer and seller. That's why you can see state agent on every high street, several state agents, Bass Street, Folkestone, Knights Frank. So you can walk in the state agent, give the details. There's again the change in the circumstances. We used to go to the state agent, we give out details, and they give us you offer a price on the property. If the vendor or seller accepts this, that's fine. You can go back to a solicitor and instruct matters. Okay. Now the state agent most of the state agent has the policy. You walk in there, you like a property, put an offer. They want to see your means. They want to see your something. It's very cool offer in principle, okay. Which means before you walk in the state agent, you probably seen your financial advisor, get a mortgage offer in principle. So state agent knows that that's a secured buyer and a genuine buyer, not time waster or not a window shopper, and they are happy to entertain you, and then they pass your offer to the vendor. If the vendor accepts, the procedure starts.
Okay. So what should someone do once the offer has been accepted?
When the offer has been accepted, the first thing you need, in this country, where the solicitor is next to the bank, we are the only institution that we can hold money, which is called client money,
Yeah.
because the system allowed it. You cannot buy any property without any solicitor. Thus, there is not if but, that's a strict guidelines.
Okay.
Any money passing bank, even the bank won't lend you money directly. The bank only lend money to your solicitor accounts, and your solicitor will complete the purchase. So when you instruct a solicitor, your solicitor will explain this thing, the procedure. The first thing, again, you have to go through what we call the KYC, know your client, which means that you have to provide your ID, valid proof of ID. You have to provide your proof of address, which must not be more than 3 months old. Then we go to it's called anti-money laundering check, which we have to do. The reason is that if we fail to the anti-money laundering check, if a client and solicitor are part of a money laundering, which is very whether SRA or regulatory body or government, NCA, they are very, very strict on that. The legislation says the maximum penalty anti-money laundering is 14 years. If anyone get caught, if a layperson get caught, he probably get something 2, 5, 8 years. Depends on the courts.
Okay.
Depends on the judges. If solicitor get caught anti-money laundering, that's 14 years.
So that's very important thing.
Yeah, because you are the
to get through the AML check.
officer of the court. You cannot like bypass any regulation,
Okay.
because criminals are. The alarming thing is there's so much mortgage fraud. I can tell you an example, which the insurer last explained to us. We have to pay insurance, indemnity insurance, what we call as a solicitor firm, and it's starting from 2 million per claim, not per firm, per claim. And it could be 3 million is a company client, it could up to 10 million pound, it's a very big client. The reason is that if anything happens on solicitor end or mortgage fraud or something like that, the indemnity insurance is provided a cover. So this is very stringent test on anti-money laundering, because you have to satisfy a regulator, you have to satisfy your firm money laundering officer, you have to satisfy the insurer that you have done all the due diligence, you have done all the KYC. Because if anyone slip the net, and thus net means the net provided by us to protect our public, protect our regulatory body, protect the other side, protect the indemnity insurance company. So many people we are here to protect and protect your client, because the client ID can be stolen, the seller ID can be stolen, and a fake imposter can pretend as a seller and sell you the property. So we are committed to provide 100% on all of these things, because criminals, the property criminals or mortgage fraud, or people are like who wants to black money to make white, that's the only tools they have available if they invest in the property market through a solicitor. So that's why anti-money laundering is very important, and we have to identify anti-money laundering from the outset, and that's we have to satisfy that this source of fund is genuine. And we have to ask, let's say if you're buying a property 100,000 and the bank gives you 70,000, the rest of 30,000 is your money. And you have to satisfy me as a solicitor that your 30% money has your own money, and that's a very legitimate trade.
But it doesn't have to be own money. Someone can give that money.
I'm coming
Yes?
to this
Yeah,
point.
okay.
So if you 30%, if you own money and you have to a legitimate trail, and you have to allow 6 months minimum bank statement, and you have to pass the anti-money laundering test, then we can only instruct the matter.
Okay.
We have a full right, if we suspect anything, we report to a money laundering officer, they will do investigate, and they say, no, that's a money laundering element, slightest element there, we politely say, sorry, we cannot continue act for you.
Okay.
Now, let's say 30% you're buying, your parents gave you gift. Now, many people, I've seen my experience, many people buying property, taking gift from friends, family. Actually, gift is only applicable to bloodline, right? The bloodline means parents, brother, siblings, uncles, own uncles. These are the bloodlines,
Okay.
right? You cannot go out there and buy property from 10,000 from your friend and say that, oh, this is the one is gifted. He is not your friend is not your bloodline. So it has for a very staggering test for us to satisfy the lenders. Then once we have there's a gifted amount, we always ask the client, go back to financial advisor, declare this to your lender. If your lender happy, we can go ahead with that. The safest is parental gift, right? But then again, when if someone gives a gift, we have to again go to the stringent anti-money laundering policy. We have to see where is the gifted money coming from. The person who is providing the gift, has he got this money in his account? So the same rule applies. We do the anti-money laundering check. We ask the donor to provide a certified copy address, independently certified, not by us, because that's conflict of interest. And then we have to see the 6-month bank statement, and we do the anti-money laundering check. Now, 10 years back, it's very difficult for solicitor to do the anti-money laundering check, because somebody physically come to the office, show his passport, and you see, and you satisfy yourself. And now there are so many companies who does ID check for you electronically. So we are safe. But again, we are safe, but we are not safe.
Okay, so in short, you have explained the role of the solicitor to check the affordability of the buyer.
Yeah.
Once they pass or they get through this affordability check, then only then a solicitor can start the work.
No,
on the
first
buying
one,
process.
yes, you're correct. First one, we see this is you who you are. You have the money, you have the enough source of deposit. You have to give us a signed source of income or source of deposit signature. You have to go to the anti-money checks. You have to give us satisfied evidence or satisfactory evidence about all of your source of money. If you have a donor gifted deposit, we are happy with the gifted deposit. We do all the compliance check.
Okay.
Once you are happy, then we ask the client, okay, we can go forward with that. It sounds so many
Complicated process.
step by it's complicated process for a lay person. For us, it's about 2 days job
Right.
to
Okay.
sort this out.
So with regards to the gifted deposit, what are the steps involved?
What terms?
If someone wants to give the buyer some money, then what are the paperwork a solicitor has to check?
First, we check this. His lender does the lender know about that? That's the first and foremost thing we
Okay,
check.
so here the lender is
Has he disclosed to the lender?
disclosed to the lender that.
Right, because why we check first? Example, he has not disclosed to the lender. Middle of the transaction, he has come to me and say, oh, I've got a gifted deposit from my sister, right?
Right.
I'm duty bound to notify the lender. So if I notify the lender will review the mortgage application again, because that's the impact on everything. You have not disclosed in the first place. The funny thing, when the client comes and tell us that, oh, I'm going to do, it's very rarely happening. I probably encounter one or two, because our clients are very sensible. They know what they're doing. And those generation, like in our community clients, elderly generation, they are not there anymore. Now the young generation, they are buying the property. So they know what's the limitation, what can do, what you can't do, right?
Right.
So if we satisfy the advice the lender, and lender know that, we can see from the mortgage offer, if there's a gifted deposit, it's clearly mentioned in the mortgage offer. So you know that. So next step, we ask them that, give us your donor details. We send them an email, and with all the declaration.
And that donor must have to, has to be bloodline. You said that, you mentioned that.
The primary guidelines has to be bloodline.
Bloodline.
But some people come, and if the lender accepts, we do not have an issue with that. As long as the donor is satisfied that he has got proof of ID, certified by independent solicitor, his proof of funds, which is in his account, again certified independent solicitor, and he has to give an affidavit signed that.
So my point is, if the donor is not bloodline, but this lender is satisfied with the donor, then that's fine. Then solicitor can.
Then if lender accept the donor
Okay.
as a part of the mortgage payment or deposit towards the deposit, we don't have an issue.
All right.
Because as long as we at the lender can satisfy, the donor can satisfy us.
What if no lender is involved?
In a cash purchase?
Yes, 100% gifted deposit.
That's a very tricky question, Farzan, because for me the 100% gifted deposit should be started alarm bell ringing.
Okay.
Right? But it can again, like, let's say your parents have got a house £1 million worth, right? And no mortgage on that. You're the only child, right? Your parents probably sold the house, they probably bought something, smaller property, 500,000. They give you 500,000 as a gifted deposit, or a what we call parental contribution. That's why. So we will ask your parents to provide us the evidence they sold the house, the completion statement from your seller solicitors, and the money is in account, right? And confirmation the money will be transferred to your account as a buyer day before the completion, and we want to see your statement, the money has arrived, right? But before we go there, you have to provide me all the satisfactory evidence, as I just said before from the beginning, that where is your source of money? 500,000 pounds. You have to go to the AML. You have to go. Your parents need to go to the AML. That sort of these things. So, but again, being a solicitor, it is a large property buying a first-time buyer, or never have your own property record, never has a property record, and buying something about big chunk of money, your alarm bell should be ringing. You should be alarmed.
Okay.
Because that's not an usual transaction every day, right? So this is what we always be careful, and we always ask our client that help us to help you.
Okay.
Most of the clients, it's very important and imperative. The client must think that you and a solicitor should work as a team. You are not a solicitor enemy. Your solicitor should not your enemy, right? But sometimes strangely, clients' tendency to rely on the estate agent, what the estate agent tells. Oh, they are
Also,
not responding.
they don't disclose everything.
They are
to the
not
solicitor.
responding. They are not working. And I explain that client, estate agent is not meant to be controlling us. Because here is I'm the solicitor, other side solicitor, you go to lender, other side go to lender. There's 4 parties involved. Estate agent is just a party to facilitate the property. They don't know legal bits. They don't involve in the legal transaction. So don't listen to them. Listen to what your solicitor says. That's basically how it works.
Okay. Unfortunately, not every transactions goes smoothly. So, what are the common problems and how to avoid them?
The common problem is that first problem is that okay, you agreed a price to buy it. The common problem is the seller probably finds a higher bidder, so they pull out and they offer the second bidder. So that's a very common problem. B, you find a house, we proceed with that, we order the searches, you pay money, and then say your mortgage offer got refused. 3, and the most dangerous part is, and there are the small problem like probate property, right? Or the example I gave it to you, you are not only one child, you got probably other siblings, but you are the parents' favorite child. That's not going to happen. That's what I'm going to deal with. I just instructed today. I'll tell you the case about this thing. Favorite student, favorite child, and the parents give you the entire money. But under the Inheritance Act 1975, your sibling has the same right on the parental property like you do. So they can say that they are defeated by your parents gifting you full amount of money which they are entitled to, right? Okay. So your siblings come to know that your parent gave you 500,000. You're happily go cheapy buying the house, but then they come in the scene. You can get a solicitor thundering letter. You can't do that. So you have to stop it. You have to advise the lender. The worst happen is that okay, you buy a house 500,000. The guideline is that you have to pay 10% deposit.
Okay, Hassan, I'll come to you later in a moment. Viewers, time to take a short commercial break. We'll be back after the 5 minutes. Please stay with us. After the break, we'll be talking more about common problems and how to avoid them. Thank you.